We look into the second week of the Derek Chauvin trial as that begins to conclude. So this is your April 9th Not So News update. Please like and subscribe if you're looking for daily news content, and let's dive on in. For reference today, I just want to give a lot of props over to the lawofselfdefense.com, who has been following the Derek Chauvin trial very carefully, and is really going to be what we base most of today's analysis on. They do have a significant bias in favor of Chauvin, which I don't personally have too much of an issue with, because all mainstream attention has been very pro or very against Chauvin. So let's dive on in. So first, Chauvin trial day 5 wrap up. Poorly informed witnesses provide state with poorly informed opinion. I personally think this day was probably the best for the state, especially because we look at how much of a mess the rest of the week's going to look. In the overview, they say that today's court proceedings brought us only 2 new state witnesses, largely because the court had decided to adjourn midday, presumably to get an early start on the weekend. This was on Friday. So the first one is MPD Sergeant John Edwards, who mainly is looking at just testifying on some of the Minneapolis Police Department policy. So here's what they report. Also, per MPD policy, however, it became known that Floyd might die and certainly was in bad condition. It became clear to everyone that it was likely to turn into what's called a critical incident. There's an MPD term of art for a police use of force that involves the death or serious injury of an officer or suspect. This is important because once an MPD use of force becomes identified as a critical incident, the substantive investigation and management of that event is taken from the hands of the MPD and handed off to state-level Bureau of Criminal Apprehension. This is common and arguably wise policy that allows the investigation of police use of force without conflict of interest concerns that can arise when a police department is allowed to investigate its own potential misconduct. It also means, however, the MPD officers are no longer involved with the case and therefore would have only had a very transient role in investigating the event, only limited knowledge of the evidence of the event, and therefore only a poor informed opinion of whether the use of force involved was justified. The main reason why this is a concern is that we see the state using MPD rather than the state level bureau in a lot of their witnesses. Why is this a concern? Is just for what we read, that the MPD isn't well informed on the circumstances of whether the defense was justified or not. You would expect those answers to be coming from that state level Bureau of Criminal Apprehension, as they would be the ones doing the overview of the events. Next, we're going to be looking at the state witness, the MPD Lieutenant Richard Zimmerman. So they report the following. Perhaps the best way to describe Lieutenant Zimmerman is well seasoned. He joined the MPD back in '85 after a few years as sheriff deputy back in the days when cops carried a gun, handcuffs, and that was about it. Often back then, from their own recollection, not even radios. Indeed, often not every squad car had a radio. Frank had a very specific role in mind for Zimmerman, and it had little to do with substantive factors of the case, and there's a good reason it had little to do with substantive factors of the case, because Zimmerman knows virtually none of the relevant evidence of the case. Much as with Sergeant Edwards, Zimmerman was almost immediately aware that this was going to be a critical incident and promptly handed over to BCA. Indeed, it was in fact handed over within 2 or 3 hours of Zimmerman's involvement. Zimmerman's role was largely as a transient caretaker of the case to ensure the uninformed officers were doing the things they were supposed to do to secure evidence, run crime scene tape, canvass for witnesses, and so forth. But everyone involved, including Zimmerman, was aware by that time that they went to bed that evening that the case would be entirely in the hands of the BCA, with effectively zero involvement from MPD. So if Frank would not be able to make use of Zimmerman to testify substantively about the case, for what purpose could he use Zimmerman? As a proponent expert on MPD use of force policies, able to provide an authoritative determination that Chauvin's use of force upon Floyd was unjustifiable. Essentially what they're getting at is Zimmerman here does not have the a purpose in this case for determining whether Chauvin's actions were good or bad. That's not in his role of this case. What he's saying is specifically is to give evidence as to what the actual MPD teaches as the use of force policies. Before getting to that, of course, Frank steps Zimmerman through the administrative role of the case as a transient character, much as Prosecutor Schleider had done earlier with Sergeant Edwards. Then we got to the real point of having Zimmerman testify. Frank asked Zimmerman if he'd been trained by MPD on use of force, if he was familiar with MPD use of force policies, and importantly, if he viewed the body cam footage of the Floyd event. The body cam footage is important here because unless Zimmerman had viewed at least that limited body of evidence, he'd had zero basis on which to have a use of force opinion. Accordingly, the prosecution had fed him the limited body of evidence consisting of body cam footage specifically so they could ask for his use of force opinion in court and then have that opinion based on more than zero knowledge of the evidence. And Zimmerman was happy to comply, providing Frank with every answer the prosecutor could hope for. The placement on the knee on the neck, Zimmerman said, qualified as deadly force because it could kill someone. There was pretty limited cross-examination by both of these witnesses by the defense, and the main reason for is that they're not actually qualified for what the prosecution is trying to prove here, which is what the MPD policies are. What they are specifically saying is that the knee on the neck could kill someone. I don't think there's really any debate on to whether it could kill him. The question really is, did it kill someone? Was it, potentially justifiable? And that's what we actually look at later in the week. So on day 6, we get some testimony from doctors that were some of the immediate responders to the George Floyd incident. The first one here is Dr. Bradford Wankeed Langfeld, who was the emergency room physician who treated Floyd. Here's what I thought was the relevant portion of the trial regarding him. Buckwell spent quite a bit of time in direct of Langfeld getting the doctor to opine that most likely cause of Floyd's cardiac arrest was hypoxia, lack of oxygen in the tissues, including by asphyxia, the inability of the respiratory system to deliver oxygen to the biological systems of the body. None of that, of course, actually settles the key issues of what actually caused Floyd's death. Even if asphyxia caused Floyd's death, that doesn't tell us that Chauvin killed Floyd via mechanical asphyxia via compression of the neck, at least not when there's plenty of perfectly viable and evidence-supported alternative explanation for Floyd's asphyxia, the threefold fatal levels of fentanyl in Floyd's system. A common theme running through Dr. Laneberg's testimony is, this is based on information I had at the time. Indeed, that's how he closed out his direct testimony. This is, of course, just another way of saying, I only had limited information about what was going on with this patient and what had led up to his present circumstance. In my expert opinion, must therefore be considered profoundly constrained by that limited information. On cross-examination by Nelson, who explicitly asked if a fentanyl, methylphenamine, or a combination of the two could cause the asphyxia observed by Dr. Landberg, the answer was, of course, yes. Nelson also confirmed the paramedics had never informed Landberg about the possibility that Floyd's condition was the result of drug overdose, probably for the reasons already discussed, although I'm speculating there. Touching upon the state's apparent lines of argument that Floyd's long history of opioid abuse meant he was somehow immune to fatal overdoses, Nelson explicitly asked Landenberg if a history of abuse meant fentanyl can't kill someone. The answer was, of course, no. Nelson also managed to get into testimony the following question, explaining further alternative explanations for Floyd cardiac arrest. Would someone with greater than 75% occlusion of a coronary artery be a substantial risk for cardiac arrest? The state objected to the question. Judge Cahill called a subbar, and when Nelson returned, he proceeded with a different line of questioning. I think there's a couple big things that we want to get out of the events that we saw with Dr. Landenberg. Specifically, he was specifically answering more as a like observer type witness rather than a professional one. He did give a little bit of justification on the potential effects of the drug usage, but he didn't actually do anything in terms of giving us any type of autopsy or medical explanation in that manner. It also went into that he did not have all the information needed to probably act on the patient. They mentioned that he was not aware of any of the drug use, which we would expect to be some type of knowledge that should have been shared from Chauvin to the paramedics to the eventual doctors. Somewhere in the chain of custody of Chauvin, there was a drop in that information. The next witness that we're looking at is going to be specifically MPD Police Chief Medero Arando. The questioning of him really wasn't, too meaningful in my personal opinion. He testified that it's the mission of the MPD to treat all people with dignity and respect above all. And really, he just kind of fits the typical, spokesperson for the MPD, so we're not really expecting much from him. He specifically went through the use of force policies with the prosecution, as well as several times he read aloud specific highlighted portions of the policy manual. The one thing that we did see out of this that I think is pretty noteworthy is that when he then went to cross-examination, there were multiple instances where Nelson, who is the defense lawyer, had essentially he read extra couple of words in each of the policies, and it really made it so there were things like instead of saying like this isn't use of force, they said that like it's an appropriate use of force, which means that there's some instances where you would expect more than them. Nelson also explored with Adarando the reality that there was a distinction between use of force policy on the one hand and permissible use of force techniques. That's what we were just discussing. Finally, Nelson got Arando to explicitly agree that just because a suspect was handcuffed did not mean they were no longer a threat to officers, others, or themselves. Indeed, Adaro explicitly agreed that a handcuffed suspect could still be a threat to officers by kicking, biting, spitting, or other means. We have to remember that this is during COVID, where going outside without a mask is considered deadly force. There was also a great deal of discussion about the neck chokes versus neck restraints, and essentially what they said is that there are some neck constraints that were explicitly permitted by MPD use of force policy and has since changed as a result of the Chauvin trial. Next, we have the Commander MPD training, Katie Blackwell. She's just another character witness when it comes to the essentially the training used for use of force by the MPD. Much of Blackwell's testimony was foundational in nature, documenting that Chauvin had taken various use of force, de-escalation, other relevant training. At one point, Blackwell testified that a photograph shown to her of Chauvin kneeling on Floyd didn't look like anything taught at the MPD training. Again, however, one must take care to parse the specific words of the question and answer. Just because something is not taught as a trained technique does not mean it violates MPD policy. Further, just because something violated MPD policy does not mean it killed Floyd. They also spent time with Blackwell exploring the issues of the asphyxia. I feel obligated to note that there is a growing evidence from authoritative sources that the whole notion of positional asphyxia is largely nonsense. My own background of this largely from my training from the Force Science Institute, which was published numerous papers on this topic. What they're just getting at there is that there's a claim that because Floyd was overweight, that it's possible that his own stomach was essentially what caused the asphyxia. In summary, there wasn't really much to Blackwell's arguments. Finally, I think day 7 was the most interesting. The first one was the Morris Hall Fifth Amendment argument. Morris Hall was the drug dealer for who's assumed to be the drug dealer for George Floyd, and he ends up claiming the Fifth Amendment during the trial. What's notable about this is that the state does have the ability to give him any type of permission to testify and make some type of bargain with him, saying that they will not prosecute. However, the state is not doing that because it seems as we continue through this, if Chauvin is not the one found guilty for the George Floyd death, it is possible that it might be Morris Hall. Before the jury was brought into the courtroom, we heard some discussion about the complication of Morris Hall, the reported drug dealer in the Floyd Mercedes SUV, announcing he was going to plead the Fifth if called to testify in the Chauvin trial. He was supposed to be one of the star witnesses. Hall has a real problem. If he provided Floyd with the drugs that likely were actual cause of death, under Minnesota law, Hall is looking at third-degree murder. Naturally, he doesn't want to testify in the Chauvin trial, only to have the testimony used against him in his own trial. There's no doubt that Judge Cahill will respect Hall's right to assert the Fifth. The only question is whether there might be some areas of questioning in which Hall could participate that do not incriminate him. This seems to me unlikely, and of course Hall's own attorney doesn't want him to be compelled to say a word about anything, but Judge Cahill has asked the defense and state to write down the questions they'd like to ask Hall, and Cahill will decide if any of them will be allowed. Incidentally, it's worth noting that Hall appeared in court via video, and his background looked like a jail to me. Zindervalk Wells, whatever. Finally, they have MPD Sergeant Kerr Jing. Unfortunately, they didn't get much to this, and I actually didn't hear anything about him during the trial. So then we get to kind of an interesting piece, which is the state witness MPD Lieutenant Johnny Mercel, who is a use of force trainer. So something to kind of look at this is one of the state experts on MPD use of force policy and training. He ends up being a very big name during what we look at in upcoming. Later on redirect, the state would attempt to diminish the damage of this bit of testimony. When the bit of testimony that they're referring to is factors such as whether a suspect has been fighting with the officer was a huge determining factor, whether an officer could reasonably provide care, even if that care would be chest compressions requiring the suspect to have handcuffs removed. The answer, of course, was no. But that was merely providing Nelson with the layup opportunity to recross to ask whether a mob shouting insults and outright threats would constitute such a reason that conduct of the mob in this event. And the answer to that, of course, was yes. Similarly, Nelson had back on the state emphasis on the whole recovery position narrative in the context of hypothetical positional asphyxia. Might there be circumstances that would prevent putting a suspect in a recovery position? Mercel answered that there were. If that all sounds bad enough for the prosecution, you ain't seen nothing yet. It's at that point Nelson showed Mercel a series of photographs captured by the body cameras worn by Officer Lane and showing Chauvin's knee on Floyd from the angle down Floyd's prone body. Photo 1, were Chauvin's leg in the image on Floyd's neck or the shoulder blades and back? Mercel responds shoulder blades and back. And in photo 2, same. Photo 3, same. Photo 4, same. This, of course, fundamentally undercuts the prosecution's narrative of guilt that it was Chauvin's knee on Floyd's neck that killed Floyd. Are there any circumstances like those discussed where it would be appropriate to maintain a presence of leg across shoulder blades and back in order to ensure control of the suspect? Yes, there are, Mercel answered. For as long as 10 minutes, it's possible. What they're really getting at in this is that it was possible for Chauvin to be working in essentially what's considered good faith with the 9 minutes on the back. This gets very interesting when we look at the next day of trial, where we have a bit of an issue where Nelson gives some more interesting questions. So this is specifically looking at testimony from Steiger. Nelson asked if it wasn't true that there were certain situations that by their very nature came an exceptionally heightened concern on the part of responding officers, like a domestic or like a robbery or a shooter. Singer helpfully suggested. Sure, answered Nelson. So sometimes an officer might have to be prepared for an increased risk. I wouldn't agree with that, said Steiger. So explain. An officer should be prepared for the highest level of risk in every encounter. So every time an officer responds, there's an inherent risk in the nature of policing, and a reasonable officer has to be prepared for the risk level to change. Correct. It's hard to imagine more helpful testimony for the defense. Nelson also gained a hit point that MPD use of force policy was not simple binary framework, if A then B, if X then Y, as the state suggested to the jury, but in the fact every single facet of the policy had qualification, if time allows, as safety permits, and so forth. Nelson then says, police don't look at force in a vacuum, do they? And Steiger responds, we should not. I look to the totality of the circumstances. Along the circumstances Nelson suggested was what the police officer knew going into the call important. Correct. Correct answer, Steiger. Do you agree in this case Chauvin was responding to a priority 1 call, backing up other officers, both of whom were brand new rookies, code 3 lights and sirens, to deal with a suspect who was as much as 6.5 feet tall and believed to be under the influence? Correct. Reasonable for the officer to rely that information as it sets the stage inherent risk of responding to that call? Yes. In the fact of Floyd's size of particular concern, asked Nelson. I wouldn't say so, said Steiger. Explain. Well, Steiger answered, I've seen small suspects be even more dangerous than large ones. Holy cow. In other words, it's not the case where an officer should not infer greater risk from a larger suspect. It's a case where an officer should infer that same risk from even smaller subjects. Nelson then asked Steiger about the extent to which an information in the 911 call should have informed Chauvin's decision making. This Steiger responded he had never heard the 911 call. You read that right. The state's highly paid use of force expert witness had never bothered listening to the 911 call that sets the entire police response in motion, and which is the foundational information officers brought with them responding to the scene. Let's get this straight. The highest paid use of force expert used by the state did not know the information that the police had when answering the call. This is what the biggest issue that we see with the coverage of the trial, why we don't see coverage coming at it from mainstream media in a fair way, is that what we're specifically seeing from the state is nothing but cases of them trying to essentially just get headlines on the news to rile people up. And we don't see them actually going about this case in what to me seems like good faith. We don't see them trying to get the truth out of the trial. What we see them is purely focusing on either getting a guilty verdict regardless of what the facts are, or getting headlines on CNN so that BLM and the Antifa protesters burn down the city. So this is your April 9th Nazi News Update. Please like and subscribe if you're looking for daily news content, and have a good one.